Welcome, everyone. My name is Barry Sander. I'm an assistant professor at Leiden University's Faculty of Governance and Global Affairs. It's my pleasure to welcome you to this roundtable jointly convened by the ESIL Interest Group on International Criminal Justice and the ESIL Interest Group on History of International Law. Just by way of introduction, the ESIL Interest Group on International Criminal Justice is a newly formed interest group. This is only our second event. Our aim is to generate reflections on what may be characterized as the outer and inner frontiers of contemporary international criminal justice. By outer frontiers, we mean issues and thematic areas where the role of international criminal justice is yet to be fully conceptualized. And by inner frontiers, we mean areas where the field is well established, but certain fundamental issues remain intractable or appear difficult to revisit. I'd like to begin just by warmly thanking members of the coordinating committee, so Professors Aman, Bagis-Castala, Chea, Lamoli, and Logiacho, as well as Ragavi Viswanath, and members of the ESIL Interest Group on the History of International Law, and members of the ESIL team more generally for helping facilitate this event. So today's roundtable is on history and international criminal justice. And what we really want to do, what we're aiming for here is we wanted to put into conversation 4 different scholars, including myself, who have recently published monographs that engage in different ways with the relationship between history and the practice of international criminal justice. So hopefully in the format, we'll be able to really engage with each other's work and think about some of these key issues that arise from this relationship from different perspectives. Chairing today's discussion, we're very fortunate to have with us Zenaida Miller, who is an assistant professor in international law and human rights at the School of Diplomacy and International Relations at Seton Hall University. Professor Miller serves on the advisory council of Harvard Law School's Institute for Global Law and Policy, where she was previously a senior fellow. And she is a leading scholar in the field of international criminal justice and transitional justice. And I must say, one of my favorite scholars in the field. I really, really appreciate her work. She is a co-editor of a brilliant collection or volume, Cambridge University Press volume on anti-impunity and the human rights agenda. So I highly recommend that. She has published widely on issues that include the exclusion of economic issues from transitional justice. And I will just promote her latest article, because why not, which is on the injustices of time, rights, redistribution, race, and responsibility, which examines the uses of the past in legal struggles over rights, race, and redistribution in different contexts. It's my great pleasure to welcome you, Zenaida, and I give you the floor.
Thank you, Barry. Okay, well, now I'm just going to start slightly embarrassed. Welcome, everyone, today. It's a real honor and privilege and pleasure to be here, I have to say. And Barry, thank you for convening all of us together and really getting this going and putting us in conversation, because I think it's a really exciting group of people, as many of you already know, and if you don't, you will soon see. It's really a privilege to be here, and I wish it was in a physical room, but I'm very happy to be in a virtual room with all of you, and maybe this was made possible precisely by that. So I'm going to introduce each of our wonderful participants very briefly, in large part because the measure of their achievements is enormous. So I encourage all of you to look them up and see in greater detail all that they have produced, in addition to the monographs we'll be discussing today. So I'm going to really, say briefly just where they are and what book they have recently published and we'll be discussing today. And then, because I want to just get into the scholarship as quickly as possible. Gritia Bars is reader in law and social change at City Law School at the University of London. In 2019, they published The Corporation, Law and Capitalism, which is what they'll be discussing today. Kamari Maxine Clark is Distinguished Professor at the Center for Criminology and Sociolegal Studies and the Center for Diaspora and Transnational Studies at the University of Toronto. Her 2019 book was entitled Affective Justice, the International Criminal Court and the Pan-Africanist Pushback. Barry Sander, as you now know, is Assistant Professor of International Justice at Leiden University, and his book, which was published in 2021, is Doing Justice to History, Confronting the Past in International Criminal Courts. Aldo Zamit Borda, is Senior Lecturer in Law at Anglia Ruskin University in Cambridge. His book was also just published this year and is entitled Histories Written by International Courts and Tribunals, Developing a Responsible History Framework. So, first of all, I encourage all of you from the top to buy all of their books and read them because they are really fantastic contributions to a field that sometimes feels saturated. And I think for exactly that reason, the quite impressive contributions that each of them have made from multiple perspectives and methodologies and in different source material, as you will see as they speak about them, really kind of demonstrate the depth of work that can go on, even in fields that often feel like there is an enormous amount of production around it. So I want to really congratulate all of them on these books and give us a chance to speak about them in more depth. So how are we going to do that? Here's the plan. I am going to ask each one of them, perhaps in the order in which I just introduced you, to speak for about 5 minutes. And I realize it is a difficult challenge to condense these incredibly dense works into 5 minutes. I'm going to ask you all to just speak about the broadest kind of themes. What do you want people to know who haven't had the pleasure of reading your books? What's the most important kind of basic thematics that we want to get into? And from there, we're going to get into a discussion, and I will ask some questions. I'll encourage everyone to ask each other questions. I think that there are some important overlaps and some really important divergences among these contributions. So I would encourage you to get into those a little bit. After we've conversed among ourselves for a while, I will open up to the audience and ask you all if you have contributions you want to make. We're happy to have people unmute, and if you just use the hand raise function on Zoom, I will call on you and you can speak. If you are more comfortable putting something into the chat, that's fine. I would just ask everyone to hold off on putting anything into the chat other than logistical difficulties until we open it up for Q&A so that we can all focus together on the conversation and interaction rather than sort of displacing some of the conversation into the chat because we really want to make this as much as possible that kind of engagement. So with that, I think we will get started. We didn't discuss order in advance, so I'm putting Gretchen in the hot seat. I hope you don't mind. I will ask Gretchen to begin by giving us a little précis of their book. Thank you.
Okay, thanks so much, Zenaida, for introducing me, and thank you, Barry, for organizing this amazing event. I'm really quite happy and a little bit anxious to be in my first academic discussion for a very long time, given this pandemic. But here we go. So my book, Corporation Law and Capitalism, was published in 2019, as mentioned, by Brill in their Historical Materialism series. It's also now available through Haymarket in paperback, which would be a lot cheaper. So it is a book about the relationship between law and capitalism. And I take the corporation as an illustration of that relationship, and in particular, the discussion on business and human rights that commenced really in a serious way around 2003 when this project was started, which is also kind of why I chose this topic. And I chose this topic also because it reflects my own journey from being a corporate lawyer to becoming a human rights lawyer to becoming an academic lawyer, which I still am for now, at least. So in the book, I propose a radical new approach to how the way we understand the role of law in the global political economy. And a radical approach requires, of course, going to the root of the problem. I use Marxist theory of law and historical materialist method to revisit the histories of the corporation of law as we know today in international law. And interestingly, I found that these origins all lie in the transition to capitalism starting in the 17th century. And the history of global corporate capitalism then with the specific puzzle of corporate power and corporate accountability in mind. And so I show in the book, using the commodity form theory of law, Pashikana's theory, that what has become capitalism's main motor, the corporation, was developed as a legal concept to congeal the relations of production, where calculable law enabled literal accountability of risk in legal relations, and I use Weber for that understanding, and minimize capitalists' risk exposure while maximizing surplus value extraction. In other words, the corporation was constructed as a structure of irresponsibility, precisely to ensure corporate impunity and the impunity of the individuals behind the corporation. Moreover, I show the nature and history of global corporate power and where it came from, and how from the 16th century onwards, the corporation served as an instrument of imperialism, causing the global spread of capitalism and the global adoption or imposition, rather, of capitalist law, what I call law's capitalizing mission. For example, through the colonial Dutch and British East India companies. Having gone through those histories, I zoom in on international criminal law specifically and the application or non-application in the context of the question of the responsibility of business actors, companies as well as individuals, and how that arises in international law after the Second World War in the Nuremberg trials of the industrialists implicated in World War II, and the sparse trials of businessmen on the Eastern Japanese front. And I find there that international criminal law functions to conceal rather than address the economic causes and imperialist nature of the Second World War, and effectively also through this to exclude economic actors from the scope of international criminal law more generally. Now, as we know, since the Second World War, after the Second World War, the international criminal law lay dormant for several decades until the 1990s, when international criminal lawyers, of course, set out both to construct the IC2I and the ICTR, but also to construct international criminal law's foundational narrative post hoc. And each of those narratives, which I describe, also contains within it a prefab constructive critique, which I argue forecloses radical interrogation, both of the existence and of the purpose of international criminal law itself. Now, however, despite the almost complete non-application of international criminal law to business in conflict at the IC2I, the ICTR, and also in national courts, of course, helped by international criminal law's strong emotive appeal, we see that cause lawyers, strategic litigators, and others, mostly members of the white Western professional classes, continue to advocate for and seek corporate accountability in international criminal law. I argue, however, that counterintuitively through this practice and combined with legalized and weaponized corporate social responsibility, this practice of corporate accountability, advocacy and practice litigation becomes part of corporate ideology, an instrument of legitimization for the liberal capitalist enterprise. So what we see by going into those histories and seeing how those histories manifest in the practice and discourse of international criminal law today, we see that the relationship between law and capitalism there constructs corporate impunity, while at the same time keeping this fact largely hidden from us through its promise of accountability forever deferred. And I will hope to go into some of that in a little bit more detail in the discussion. Thank you.
Thank you so much, Greta. That was great. Kamari, next up.
Okay, thank you to Barry and to all of you for being here and for having me participate in this discussion. Also to the ESIL International Criminal Law Group for the invitation. I mean, I feel as if we should just stop right there and discuss her book, their book, because I can see lots of overlaps, of course, in relation to my own, but really the kind of radical interrogation that's being proposed there in that text is very exciting and compelling, and I'm looking forward to the discussion. But before going there, let me say a little bit about my book and what triggered the interest in this theme. And when they just presented their book, I thought, let me run and get mine. So Affective Justice is the text, and the subtitle is The International Criminal Court and the Pan-Africanist Pushback. And in many ways, the history is certainly central to the ways that I'm conceiving of this concept of affective justice, but it's also about the present and the contemporary and our futures. And so one of the instigations for what triggered this book really had to do with the International Criminal Court's Africa focus. How do we understand it? How do we conceptualize it? But more important, what are the enabling conditions that allow us and that allow the triggering of criminal jurisdiction, international criminal jurisdiction, to happen in this context, according to these patterns, according to these geographies? How are we to make sense of that? And there's no other way to do that. Certainly we can do it in terms of the present, the recent past, what happened, who killed whom, etc., but it's not enough. Because in many ways, the individualization of criminal responsibility in the rise of international criminal law is part of the problem in producing a particular way of thinking about justice and thinking about culpability. So why I wrote the manuscript in many ways was inspired by that question and the inability to answer that question according to conventional approaches in international law and socio-legal studies, as well as legal anthropology. And so instead, some of what affective justice attempts to do is to think about people's understandings and embodied engagements in the production of justice in relation to structures of power, the forms of history, as well as contingency. So history is not everything. Contingency counts for something, but they're interrelated in an assemblage that produces a particular kind of international justice that we are seeing unplaying out that we're seeing unfolding today. And so, so how do I do that? Well, the optic in many ways is various African constituencies and their pushback against the International Criminal Court, or larger, more monolithic international criminal law. And in part, I'm interested in theorizing the role of affect and affective approaches in shaping how we understand justice in the contemporary period. And part of the problem, of course, is what I call legal encapsulation, the production of a particular language of justice in the contemporary period that seems to equate justice with law. Increasingly, this, of course, we see with the judicialization of justice, the rise of the judicialization of politics everywhere, and its implications. So the book is based on fieldwork over a 6-year period in which I played various roles, from interviews to working as a technical assistant, a technical consultant or advisor to the African Union Legal Council. And so from fieldwork in The Hague to Addis Ababa in Ethiopia to the African Union to mapping and interviewing and making sense of post-election violence in Kenya and Boko Haram circuits in northern Nigeria, really the idea has been to look at a number of case studies to think about how we make sense of people's understandings of various violent pasts, and how we can think through an affective justice framework to make sense of the complex or the complexities of justice. And so some of the key concepts I've mentioned: legal encapsulation, another one that I call affective reattribution, which is a form of pushback. It is a way of reattributing guilt, not in terms of conventional legal conceptualizations, but reattribution that often calls on history, that brings us to modes of culpability that aren't traditionally seen in law and in Western law. And through that, I think about the ways that we see the emergence of three key imaginaries, one of them being the production of a victim that gets mobilized around anti-impunity formations, the production of the notion of an individual perpetrator, which itself is a fiction, and the rise of this notion of the international community that is there to intervene and resolve or ignite juridical and political and other modalities to address social injustice. And so ultimately, to end, since I don't have much time, just to end by saying that it really, the book attempts to rethink or to deploy assemblage theory to rethink a particular kind of geopolitics that's multi-scalar, that uses techniques that allow us to see beyond the framework that law often offers, and to demonstrate the political and emotive and sociological and the role of technocratic knowledge in understanding what justice is and how people produce that notion of justice. And so I'll stop there, and looking forward to hearing the others.
Thank you so much, Kamari. And I think, as you can all see already, the kind of really interesting relationships between a lot of these arguments, in particular about, ideas I think we'll continue to see as Barry and Aldo speak about individualization, about how we think about colonial and extractive histories, and sort of the modes of how doctrine and history interrelate. So I will turn it over to Barry next. And thank you all for doing such a concisely presenting incredibly complex ideas. So, Barry.
Thank you, and thank you to Kamari and Gricha for that wonderful opening. So my book, I don't actually have a physical copy of my book yet, so I need to get on Oxford University Press's case about that. So I can't unfortunately do the holding up of the book. But my book began really in 2012 as part of my PhD. And there were really 2 points of departure for my research project. The first was that in 2012, it was a pretty interesting time for the field of international criminal justice, because institutionally, the field had exceeded all expectations, right? There was a degree of judicialization that few had thought imaginable sort of decades ago. But normatively, or in terms of its objectives, there was a sense that the field was failing to fulfill a lot of the aspirations that were being invested in it, whether it be justice for victims, deterrence, reconciliation, peace, you name it. And this triggered, at the time, considerable questioning of the faith that was being placed in international criminal courts, and questioning that continues to this day. Questioning the identity of these courts, the meaning, their purpose. So I think, for example, you have Merjan Damascus' article, "What is the point of international criminal justice?" Already starting to think through these questions. What are we doing here? And then you have Christine Schwabel's edited volume on critical approaches to international criminal law, which came out in 2014, I believe, which really began developing a more radical critique, questioning, the underlying assumptions of these courts. So that was the first point of departure for my project. The second point of departure was that whatever else, my instinct was that whatever else these international criminal courts are doing, it seemed clear that they were narrating history through their judgments, contesting history through their trials, archiving historical materials in their archives. And I refer to this as the historical function of international criminal courts. So we have this reality that there is a narration of history going on in these courts, and we have a context, a climate of discomfort, self-questioning, and critique that is emerging. This is at the beginning of my project. And essentially the overarching aim of my book is to see if it's possible to understand international criminal courts, to understand what they are, what kind of justice they render, what functions they serve, what are their emancipatory limits and potential, through the prism of this historical function. And so I have essentially two sets of research questions in my project. So first, I ask whose histories are being produced in these courts, which actors, processes, and practices exert most influence over the scope and content of the historical narratives constructed in the judgments of international criminal courts. And then secondly, I ask what histories. So what tends to be included and foregrounded, what tends to be marginalized and excluded from the narratives constructed in international criminal judgments. And my hope is that through examining these questions, the book can provide a deeper understanding of what international criminal courts are and their emancipatory potential and limits. So essentially, the book looks at a number of different contexts to sort of answer these questions. It looks at the international military tribunals at Nuremberg and Tokyo. It looks at the UN ad hoc tribunals, the Tribunal for the former Yugoslavia, Rwanda, and Sierra Leone. And it looks at the International Criminal Court. And essentially what I seek to do, and here I think there is some similarity actually with Aldo's sort of framing of his book, is I seek to look at the legal practices of different actors. And I look at how statutory frameworks were drafted, how charges were oriented in particular indictments, and how legal categories were interpreted in the decisions and judgments of these courts. And I seek to examine these legal practices with respect to three questions that tend to structure the narratives contested and constructed in the trials and judgments of these courts. So first, I look at what I call the prosecutorial targets question. So which categories of persons, which situations and categories of persons are targeted for investigation and prosecution? Secondly, I look at the crime question, which is, which categories of crime are sort of prosecuted in these courts, how are they defined, how are they interpreted and contested? And finally, I look at the culpability question, which is, how is criminal responsibility attributed for the commission of these crimes to particular categories of person? And so with the remaining part of my time, I'll just kind of give you the snapshot of my findings. Essentially, what I find is that the histories produced by international criminal courts are there are three overarching characteristics of the histories produced. First, they tend to be what I call apologetic histories. International criminal courts construct historical narratives that are shaped and restricted in significant respects in accordance with the established relations of domination that exist both between and within states in the international political order at particular moments of time. These are hegemonic histories, a conclusion revealed most clearly not by the fact of their selectivity, but by the substance of their selectivity. What are their silences, what is included and what's excluded? The second feature of these histories is that they are spectacular histories. And here there are clear resonances with the work of Kamari and Gricha, whose work I think I rely on at various points in my book. And that's the point that the international criminal courts have focused primarily on adjudicating spectacular harms, what I refer to as spectacular harms, foregrounding a narrow set of egregious physical, direct, and immediate forms of violence, and marginalizing, in general, economic, social, and cultural forms of violence, as well as structural and slow forms of violence. And finally, the histories produced by these courts are narrow. And I mean this in two senses. First, they're narrow because they examine predominantly the behavior of political and military figures rather than economic actors. And here there's, again, resonances with Gricha's work. But also they examine political and military figures within localized systems of criminality to the exclusion of broader international networks and structures. Think international financial institutions, illicit arms and diamond trade networks, international peacekeeping forces, and colonial actors. And secondly, they're narrow because they tend to emphasize how the collective and systemic dimensions of mass atrocity environments may expand the agency of individuals on trial, but afford very limited space to critically reflecting on the widespread societal acquiescence that characterizes these situations, the dilemmas and ambiguities of agency experienced within these situations, and the possibilities that may exist to exercise agency and build solidarity to resist in these situations. So drawing to a close, taken together, the apologetic, spectacular, and narrow nature of the histories constructed within international criminal judgments reveals a somewhat ironic picture. Courts promoted as mechanisms to challenge denial have risked becoming forms of selective amnesia and instruments of legitimation. And in the final chapter, and I can talk about this later, I elaborate two perspectives that may open up avenues for orienting the practices of international criminal courts towards a more emancipatory politics. But I'll leave it there for now, and I'll hand it back to Zena. Thank you.
Thank you so much, Barry. That was great. And yes, I think some of those themes, particularly about sort of how these function and also, is there emancipatory potential? And if so, how will be interesting themes for us to take up. But first, let us turn to Aldo. Go right ahead. Tell us about your book.
Thank you, Zena. And firstly, what an honor it is to be able to say a few words about my book, Histories Written by International Criminal Courts and Tribunals. I have it here, right on cue, though no fancy artwork, just a very, very red cover. So before you buy it, be careful about color clashes on your library. But again, thank you, and thank you, Barry, for organizing, fellow presenters, guests, and also the ESIL International Criminal Justice Interest Group for hosting this event. If I had to sum up my book in one sentence, I would say the following. To the question whether international criminal judges and prosecutors should aim to write historical narratives of the conflicts that come before them, I would answer yes. But they should aim to write them responsibly. And I think in today's symposium, we have quite a rich variety of perspectives outlining the strengths, limitations, challenges represented by international criminal justice and the role of history writing within that process. And within this range of perspectives, we go from the more critical and radical perspectives to perhaps more favorable assessments of international criminal justice and criminal adjudication. And if I were to position my book in this wide range, in this spectrum, I would say it occupies more or less the middle ground. And in fact, in my book, I seek to develop what I call a responsible history framework. The truth is that I did not coin that term myself. Professor Anton de Beets did, and I see he is here, and so very, very welcome, Professor de Beets. Professor de Beets used this concept of responsible history in connection with concerned historians and how concerned historians should go about writing history responsibly and ethically. I now use that concept, but apply it to the work of international criminal judges and prosecutors. And I argue that judges and prosecutors should not avoid writing historical narratives. They cannot, and they should not. However, they should, as Professor de Beets writes in relation to concerned historians, they should strive towards writing responsible histories. And I'll be happy to say a bit more what I mean by responsible histories, but very briefly in this introductory remarks. Firstly, responsible history means, therefore, recognizing the value of history writing in international criminal adjudication, in spite of the limitations of these histories. And we will hear a lot about what these limitations are. And this is in part because international criminal courts and tribunals have the potential of uncovering truths about conflict and uncovering truths, therefore, for survivors and for society. They should, however, go about writing history in light of the virtues of accuracy and sincerity. And these are, you will recognize them, the two virtues of truth developed by Bernard Williams, amongst others, in relation to the search for truth. A third element of what I call responsible history is the recognition, however, now of the limitations of the historical narratives that international criminal courts and tribunals can write. And I'll just give two examples here, but there are many. One, for instance, is what has already been mentioned, the individual-centered lens. International criminal courts and tribunals mainly write history from the perspective of individual agency, with some exceptions relating to theories of collective liability. So this lens does have the advantage of focusing on acts of perpetrators in the present, but it does tend to de-emphasize other important explanations of violence, and such as root causes and colonialism or structural causes. And indeed, Kamari has already mentioned how some would consider individualization of criminal responsibility as being part of the problem. And another limitation of the histories written by international criminal courts and tribunals would be the time framework. And Zina, and you cover this in your article on injustices of time. There are no consensual criteria for identifying the beginning and end of violence. And Shaklar notes that, for instance, those intent on rehabilitation will look to go back in time to the root causes of the violence, whereas those intent on simply ridding society of dangerous deviants will begin much, much closer to the present. For them, the but-for, the sine qua non test would be sufficient. So these are just two limitations of the kind of histories that international criminal courts and tribunals can write. And just to be clear, I'm not saying that courts and tribunals should expand their focus and start including structural causes or broadening as much as possible their timeframes. I am not saying that. All I am saying is that when we approach histories written by such courts and tribunals, we have to be fully aware of their limitations in addition to their strengths. And the fourth and last element of my concept of responsible history, again, aligns very closely to what others, but in particular what Barry's work. It is that idea that the historical narratives written by international criminal courts and tribunals should be approached as discursive beginnings, as a contribution to the discussion of history, rather than some authoritative or final version of that history. They have to remain open to being revisited and reinterpreted in the future. So that in a nutshell is what I try to do in my book, Zina. Thank you.
Thank you so much, Aldo, and to all of you. So I'm going to just, I will get the ball rolling a little bit, and then I'll encourage all of you to ask each other questions. I'm sure you have many for each other. So don't take it as a Q&A, take it as a discussion. But I did want to start, sort of, I think already one of the kind of interesting themes here is about essentially what international criminal law is doing. So, and we can think about that in a couple of different ways. One is to really focus in on the history question, which is also a temporality question, right? So each of you in different ways is speaking about both the internal production of historical narrative that happens sort of in the moment of legal judgment, but a number of you are really also speaking about how kind of longer form ideas about history, inequality, and structure are feeding into, very much in Kamari's work, right, how the kind of regime is developed in a way that happens very much outside as well as inside the courtroom, right? So the ways in which the affective regime is kind of produced in this kind of in different emotional modes that pick up on long historical trajectories. So that's a kind of torqued way of thinking about the role of history in time. And I think also Breach's work, which is really kind of both drawing on the histories produced within as well as the histories coming from without. So I want to take that, and the reason this is a little bit of a two-part, and I'll just let you sort of go with it as you'd like, is there's that piece of it, and then there's the other piece connected to it, which is kind of what international criminal law is doing in the world. And I think each of you have kind of theorizations in your books about the idea that it's doing a lot more than, right, the judgment, and that's something we think about commonly in our field, but I think each of you has a very different approach actually to what those courts, right, what is actually happening that has so much import to the kind of world at large. So that's I guess that one is more of a preview. Maybe we'll start with the history one, just to keep with our title and theme. And because I realized that was two big questions morphed into one. So I'm going to give you time to think about the second one. So maybe just on that first one, how you think about the issues of history and temporality in the work that you're doing. So Barry and Aldo both have quite, direct, right, it's very much about the historical narratives being produced and how that is then picking up on sort of wider histories that are left out, marginalized, displaced in non-accidental ways. As you both show, there's a doctrinal production of that in the modes of selectivity that happen. I think Kamari and Gritcha also are speaking about the ways in which very much longer histories and particular histories, right, are both experienced and then fed into the kind of ways in which these doctrines and judgments perform. And then are received, right, which is a huge part of it as well. So I'll just open it up maybe on that front about how each of you are kind of approaching these sorts of themes around history and temporality, and how you see the particularity of your contributions in that mode. And I will not call on you. I will give you the freedom to choose which of you would like to speak about this question. I mean, I can call on you, but, you know, cold calling is terrible. Aldo, I see a hand raised. A physical hand raised.
They're big questions, and I spoke last, so I won't take too much time on it. But they're very big, and I'll just give some ideas from my work. Two broad ideas. So, in terms of how history operates and how I see history operating in international criminal adjudication, I think the starting point would be the relatively uncontroversial point that international criminal courts and tribunals, international adjudication is different from domestic adjudication in sort of normal crimes. So atrocity crimes are qualitatively different from, you know, your theft trial or etc. in a domestic court, and international criminal courts and tribunals occupy the space somewhere between an international criminal court and the transitional justice, where you are looking towards now history, truth, reconciliation, and other objectives of that justice. And with that in mind, therefore, the starting position for me, at least, is that courts inevitably have to write histories whether they want to or not. Not only that, they are blessed, if you will, with authoritative, with authority and with epistemic authority, and therefore that is inescapable. And therefore, the question is really, how do they use that epistemic authority in the best possible way? Now I know, and I will stop here, but I know that colleagues might envisage rather other systems that could do this process better. But I start with the process we have and ask, how can it be improved?
Thanks, Aldo. Others on this point, Kamari?
Yeah, thanks. I'd like to, I love that question, because I think, and I actually see both questions as interrelated. So this question about what ICL is doing with the world, in many ways, to me, it's magnifying inequality, in fact, which is contrary to what some might respond. Some might say it actually puts in place an emancipatory potential to protect victims. And I think that's far from the truth, in fact, that the way that I would approach this question and the way that I think about this in relation to the book and so much of my work is that modernity and the making of the world as we see it has been replete with violence and structural inequality, with land theft, with name theft, with subjugation. And so the world are the modern organizing mechanisms, whether it's ownership of property or whether it's land or what have you, is fundamentally about those social injustices. And at the moment in which we are seeing in the 21st century and in the 20th century, the emergence of nation states, independence movements, etc., we also see the emergence of a legal regime and an international criminal regime that was not available to adjudicate colonial crimes and ongoing crimes, but that is available to adjudicate the product of that violence. And this is part of the problem. So history is fundamentally, this history is constitutive of our contemporary problem, but the nature of violence that we're seeing is far from individual. It's political violence, and it's fundamentally connected to the making of our contemporary world. And so international criminal justice, while we might say that it's emancipatory, it's a mechanism to protect victims, you know, in many ways, we also have to be real about the larger, and this is where history is critical, because the larger, the 100, 200, 300 years, 1492 onward in terms of the Afro-Atlantic world, that we're talking about a much bigger, much larger mechanism at play that's about social injustice, and the very narrow post-World War II tools of international criminal justice that we neatly use to apply to, you know, individual culpability is deeply problematic and ineffective. It doesn't really speak to the larger problems of structural inequality, whether we're talking about Palestine or indigenous peoples in British Columbia, or people in the Caribbean, or Americans, Black Americans in particular, and BIPOC people who are suffering from police brutality, etc. Whether that violence is manifest in a range of ways, there's no discontinuity from these larger structures. So for me, then, to wrap up this longer history and the ways that I think about history and the text in relation to international criminal justice really is a manifestation of a fiction that that we use symbolically, but that doesn't quite address larger structural problems.
Yeah, thank you. And I know I was anticipating exactly that hand, because I just thought Grisha is going to have a great explanation of also how this evolved. So I thank you, Kumari. And I think that, right, we also have this framing of when international law, presents itself, right, as the answer to the problem. And as you were saying, right, the sort of notion of it also being produced, the ways in which it legitimates itself, particularly in the ICL realm, are also part of that historical structure itself, right? And so the production of that idea, I think, as you said, right, that we have these modes of violence, and then there is this presentation of an answer, which is in fact produced in the moment of the problems that were never resolved and certainly won't be through this practice. So I think that it's a very interesting weaving together in that way of kind of how we think about these, longer timeframes and continuities, but then also the kind of legitimating factor of these courts and this particular operation of legal practice, and how that's built into, these kinds of massive modes of continuous violence and dispossession, which I think is a neat turn to Grisha to talk about that.
Thank you, Zina. Yeah. So what does ICL do? Does it reproduce global inequality? Does it reproduce itself? Or does it reproduce state and state violence? Or does it destroy any or all of these things? And I think it has the potential to do it kind of does all of these things, or tries to do all of these things, but does so imperfectly, right? So I think that it tries to hold itself out as a symbolic thing, that, like this symbolic, a bit like Lady Justice with the sort of, it gives us a judgment. It selects these cases, and of course we know from Barry's work, and we know from Aldo's work, that it doesn't do the selection and the actual production of the trials. It doesn't do so perfectly, and it doesn't come across to the world necessarily as the perfect finding of truth in a situation, as it seems to present, as it would like to perhaps present itself in that fiction. But at the same time, there are only very few people in the world that actually look to the International Criminal Court for that, right? Like who's even heard of them? Some people, that perhaps as lawyers, we tend to attach much more significance to law and legal institutions than perhaps we should. And so at the same time, yes, if we do look to it, and we do look to it, and I've been reading Kumari's book as well, and I do I feel really compelled by the way that it discusses one of the main questions that I always have in my mind, which is why does it, for instance, I spent 3 years working in Palestine, and the question, why do people still demand a legal solution despite what they've seen, despite having been to the ICJ and back and still nothing's changed with the advisory opinion on the wall, for instance, despite, why in your examples as well, Kumar, you talk about this almost kind of mythical power that, you're saying this equation between law and justice holds. And at the same time, of course, International Criminal Court judges know, as well as judges in domestic courts, that only certain types of judgments will reproduce the legitimacy of the court itself, right? So if a court comes up with a really crazy or out there judgment, it knows that the court will lose its legitimacy. So it has to always find, really, in a really careful way, find that judgment that will be just about, or will be supported. And what we've seen, for instance, in the Nuremberg trials of the industrialists, is that the judgments that were handed down outraged both, the lawyers on all sides, right? Lawyers, it was very plain to see, and I do some close reading of some of the decisions in my book. It's very plain to see how the narrative of even the prosecution, the defense changes throughout in the trial when the political interest of the great powers change, right? So what you get then is the fallout. So the fallout is lawyers and former prosecutors and former investigators all writing their memoirs and being outraged about what happened there. And that, Kumar, you also talk about the way that the sort of artificial equality that exists within the court creates space for the counter argument, right? Or for one counter argument, at least one counter argument. And that is interesting in the sense that obviously a judge can't always control the space that counter argument ends up taking up outside of the courtroom, although they can sort of know what their balancing act in their judgment eventually is like trying to contain that in such a way that it still gives some space, is enough space for the judgment to be legitimate, but not enough space for the counter argument to become more powerful. Now, so the question, why do we put up with it all? Why do we put up with it all if it does reproduce inequality, right? What I'm seeing and what gives me a lot of hope is that more and more people around the world are seeing that legal system. For instance, if you look at the Black Lives Matter call for the abolition of the police and the prisons and so on, right? So more and more social movements and groups and individuals and scholars are starting to see how in fact the decisions that come from the system, or the products of the system, or the system itself, creates something that we don't want, that doesn't accord with our understanding of what justice is, right? So law and justice no longer equate in that way, and so perhaps this is a moment when there are already movements within Palestine, of course, and I don't know enough about the context in that you described, Kumar, but I imagine that there are also with the withdrawal from the ICC, but not just that, but also more broadly, people embracing a sense that a structural change is needed, and an abolitionist perspective is being adopted that sees us forced to and desiring to construct institutions that will articulate justice in the way we understand it.
Yeah, Barry.
Okay, so this is really fascinating. A lot of things to react to. So just thinking about this question about history and temporality, I think one of the things that I've tried to think about in my work is the idea that actually the narratives that are constructed in these courts, they're not fixed and static, right? So obviously narratives travel throughout the entire international criminal law process where they're contested, but then there is this kind of moment of judgment, which, as lawyers, we're told this is the moment of finality, this is the moment of closure. But actually, if you look at the work of the tribunals in particular, which have produced a series of judgments, a collection of judgments, at various points, judges revisit narratives from former judgments, and actually, they evolve over time, maybe because there's new evidence, maybe because there's different interpretations of legal categories, maybe because the prosecutor has just brought slightly different charges on a similar situation. So there is this kind of narrative evolution or ongoing contestation inside the courtroom, but also there's ongoing, and this is where I think it links a little bit with Kamari's work, there is this ongoing contestation outside the courtroom, right? So it's not just, a judgment is produced. These are quite dense judgments. Not many people read them. And a lot of the time, these judgments are filtered through sort of local carrier groups, whether it be the media, whether it be local politicians, and that can actually have an influence over the understanding of different communities on what these judgments actually say or purport to say, or how you react to these judgments. And I think Kamari's work is particularly interesting in this regard, and really pushes the field forward. To be honest with you, I'm quite in awe of your book, but it really pushes the field forward in really grappling with some of the emotional regimes. And forgive me, I'm a lawyer, so I may be misstating some of the concepts, but some of the emotional appeals that occur, once we move outside of this kind of courtroom context, and how that evolves and is constituted. So that's the first point. The second point that I wanted to make, is about legitimation. I think almost consensus, I think, amongst the panelists that the focus on the individual, there is a risk that this focus on individual criminal responsibility identifies the cause of mass violence in the body of the individual, to the exclusion of the fact that the individual is to some extent a symptom of wider structural phenomena, right? I think that that is clear. And the question, I have a question actually for Kamari is, you discuss in your book about the Malavo Protocol, and I just wondered what your opinion was on in general on the Malavo Protocol. Do you think the Malavo Protocol holds out more promise as an institution to the ICC? I'd be really interested to hear your perspective. I realize that's not your project in the book, so to speak, but nonetheless, I think it's a really interesting, development in the field, which we can discuss, because obviously it has this wider jurisdictional remit. It has the potential to prosecute corporations and a wider set of crimes, but it remains at heart a criminal law institution. So, I think there's some interesting questions there. And then finally, Greach, is why do we keep coming back to law? I found useful in thinking about this the work of Paul O'Connell, who's also a Marxist international lawyer, who talks about this idea of emancipatory multilingualism. It's one that I draw on in the book, and that's the idea that I think that, and I'm surmising here, that social movements keep coming back to the law because it is just one of many available avenues for redress. It's there. So let's just try. Let's just try and use this. I'm pretty sure that most social movements are quite eyes open that it could really fail a lot of the time, and that the law is not always on their side, for sure. Just look at the status quo, and that's what they're fighting against, right? But it's one of several strategies that can be, or tactical interventions, I guess, to use Rob Knox's strategy tactics dichotomy. It's one of many tactical interventions that you can make as part of your broader struggle. The conclusion of the book, I talk about the Global Legal Action Network's communication to the ICC about alleged crimes against humanity concerning the Nauru and Manus Islands. And really, my sense was that communication, those who were kind of making it didn't hold out much hope that it would really go anywhere. But it was just one of several avenues they were pursuing to try and mobilize attention and mobilize their movement to deal with regressive migration policies. And so, yeah, so I guess my question to you, Gretchen, is, do you hold out any hope in the legal sort of strategic litigation realm, or is it all doom and gloom in that respect? So yeah, so that's just a few thoughts to get the conversation going.
Those were great questions. I feel no need to add questions now. And if either of you want to address Barry's points, I'm happy to say more, but I would love to hear your answers to those questions.
Kamara, please go ahead.
Okay, I'll go ahead. So yeah, Barry, thank you for those discussion points. I think they're all excellent. And I'll just take up one of them, the question about the Malabo Protocol, because this question sometimes is brought to me as a challenge in a way that in fact, I'm talking about the critical engagement with the ICC, yet in the second half of the book, I look to the African Court and its Malabo Protocol as an example of a domain of justice, which actually isn't quite what I do in the book. And I know you're not saying that, but what I see here is, on one hand, it's the emotive, it's the affective spirit around which the Malabo Protocol in an African court emerges that's of interest to me, but a couple of other things are of interest. Let me say a few things about the Malabo Protocol for people who don't know, and I'll do it very quickly. So in response to, after the multiple indictments, many indictments of African leaders, what we saw was an attempt to expand the criminal jurisdiction of the African court so that it included a number of crimes, all of the ICC crimes, but also another 10 crimes that are economic crimes for the most part, drug trafficking, toxic dumping, piracy, explicit the extraction of natural resources, a whole range of crimes that African leaders, African statespeople were saying that these are the crimes that are threatening and are most important on the African continent. And so there was a move then to, the Malabo Protocol was passed, and there's a process of ratification that is 15 countries have signed, but no one has ratified. And so what's interesting about the Malabo Protocol and this attempt to create a parallel mechanism is not that African leaders are saying we fully believe in the spirit of the law, but they're saying if we want to think about culpability and liability, let's make corporations responsible. So the introduction of criminal corporate liability, the introduction of modes of extraction that are key to the nature of violence that the ICC is pursuing. So, and in fact, it doesn't radically change temporal jurisdiction in any way, but the introduction of new modes of subject matter jurisdiction is interesting. But still, there are no ratifications to this protocol, and the court is not operable. It's operable as a human rights institution and other things, but this merger that was part of the vision is, I think, the effective justice component that is interesting. But what I do in the later work, because when I was writing effective justice, it was clear that it wasn't clear what would happen or become of the court. Some 4 years later, there are 0 ratifications, and no one wants to touch it with a 10-foot pole because of the immunity clause. No leaders that are still in office will be held culpable or held accountable while they are in office. And the introduction of that as a revision had severe consequences for the operationalization of the court. And so just to end what What I would argue is that we look at this court not as a radical re-envisioning, but an important example of an effective response. And that we also think about, following Sarah Ahmed's work, think about the non-performatives that are part of these justice articulations. So the idea that there are certain speech acts and certain actions that produce nothing, right, that don't go beyond the actual statement of them. And what we have with the African court, I think, is a non-performative, the production of a juridical alternative that maps out a response that is a rejection of particular designations of the four core crimes as the crimes of significant concern to all of humanity. And instead what they're saying is no, criminal corporate liability. There are a whole range of other things that actually are part of the core challenge here. And I think it's a non-performative. It isn't emancipatory, but it does demonstrate a reattribution of how we should understand culpability.
I think it's such a good transition maybe to Grisha speaking a little bit about the strategic point, because I was thinking as you were speaking, Kumari, that, I mean, I think with a number of you, there is this sort of notion of the inevitability of kind of these institutions, because of institutional path dependence and everything else, right, are continuing to operate and sometimes even being constituted in new or different ways, right? In a way that is, as you were just saying, Kumari, right, not emancipatory, but there is, maybe a strategic element and certainly an affective element of kind of, that mode, as you're saying, in a non-performative speech act of, what it puts out there, right? What it makes clear in the world that is a gap. So I am really interested, Grisha, in this point, because I think it also, in your preface, if I could ask you this sort of as an add-on, and then feel free to just answer the question directly and not touch on this, but, you talk in the preface, I think, about Mikhail Svard's book and work, who's a lawyer who was asked a lot of these questions about sort of how you do the work of, say, human rights lawyering under occupation, right? So in a situation of radical architectural structural injustice, right? What does it mean to keep doing the work? So, and I really liked your weaving of that into the book for yourself, of the way, I saw it in the background of a lot of what you're discussing in the work. And I think it goes to Paul O'Connell's work as well, about that sort of accepting of the work that's already happening, finding, partially strategic while accepting that there is so much circulating that is not only uncontrollable, but tilted in a certain way already. So I basically, because I loved Barry's question, so I hope you don't mind that, I just wanted to piggyback onto that one, because I think that sort of question of how you continue to, what does it mean to do the practice or do it strategically, while at the same time understanding it to be not just problematic, but embedded in the way that Kumari is speaking about, right? And I think, which, in different ways, Aldo and Barry's work brings out too, as well as yours. So that's just my piggybacking on. Go ahead.
Yeah. Yes. Yeah. Thanks, Zena, also for your input, and I really welcome your participation as well in this conversation, because you've obviously also written extensively on this subject area. And about, I always get asked this question, right, about do you really think there is no point in doing these legal actions? And my very close colleagues are involved in GLAN, for instance. Very good friends of mine work there. Very good friends of mine are human rights lawyers in Palestine and so on. And of course, I see there being use and need for that. And for instance, it's really strategic litigation is a really great way to get a story into the media that perhaps wasn't in the media. It's a really great way to get disclosure, right? To get a company, for instance, to disclose a lot of its internal documents that you wouldn't otherwise have had access to. So it's good. An information knowledge is power, right? So even if the court decision doesn't go your way necessarily, you've still got that information that's going to help you outside of the courtroom. It's really useful in sort of public debate to have a number of really well-regarded human rights lawyers take up a certain issue and make clear and strong statements about the situation, even if, as is almost always the case, the courts do not go your way, right? Because we know that from, for instance, alien tort claims cases, hundreds or even thousands have been brought, and how many of them, I don't think any of them have actually resulted in a positive court decision, right? So a finding of liability of companies with, other than simply the technical possibility thereof. I think the closest it came we had to it was the Arab bank cases, which were about like funding of terror funding, etc. So yes, it is good to pursue these cases, and each time, of course, I am tempted also by it, but I also wonder where that question comes from, right? And it often comes from lawyers. We are trained in law, we love law, we love that we have this expertise, we have these skills, we have studied long and hard to get our qualifications. We find it hard to let go of it. And I think people in general also find it hard to let go of the idea of law and courts and justice being good things and being like things that we need in life and in society and in the world. It is a massive leap of faith or leap into the unknown to sort of try and start creating alternative forms, transformative justice, etc. Every time, and again, of course, in Holland, we had recently the Shell case, right? I'm sure you've seen this. So Shell was told by a Dutch court that it had to reduce its emissions in alignment with the climate accords. And so this was, a big climate case brought by Milieu Defensie, a big climate NGO, right? So it's like something that people, NGOs and activists and so on have been fighting for years, for decades. And it was celebrated as a massive win against a massive global multinational. But at the same time, the question, what is going to happen? Like literally, what effect on climate change is this decision going to have? And of course, it's going to be replicated in other courts around the country, every time around the world. So that they're already preparing cases in other jurisdictions where Shell has a presence or where Shell has, can be found to have, where standing can be found, etc. Every time I hear of these cases, I think, do I need to eat my hat today? And every time I think, maybe I need to eat my hat today, but actually, no, I don't need to. Because at the end of the day, what I keep coming back to is this idea of literal accountability, right? So what a company is able to do, what a company's, of course, there's too much there to. I don't have the facts and the numbers, etc. on hand. If you, for anyone who speaks Dutch, actually, the correspondent did a really great debate on this court case between three different people who were involved in it. If you're interested, I can see in the list of participants some with Dutch names, so that would be recommended. But the conclusion was that in the end, for actual emissions, what they're being asked is not very different to do. Is not very different from what they're doing already, and it's more symbolic, right? So it's not actually going to be massively effective. And also, if, for instance, Shell doesn't explore the Arctic, some other company will take up that license to explore the Arctic, etc. So that's kind of it's a zero-sum game in that sense. Now, I would say though, and I want to commend Irina Church's work on movement lawyering, right? So, and Dean Spade's work, which is on the necessity for survival of certain litigation and certain, so for instance, housing lawyering, immigration lawyering, defending your comrades who've been arrested, etc. Those uses of law, I'm obviously, we need to not hold back on any of those. It's the strategic litigation cases that are more symbolic that have more of an issue with, because at the same time, and also with this idea of corporate criminal liability itself, of course, functions along the logic, the carceral logic, right? The logic of the state as a punitive actor controlling population. And what you see is that, obviously, as I mentioned earlier, the movement of abolition, moving away from the carceral logic of dealing with conflict and with even transgression of norms that exist within communities, or violence or whatever, in different ways. And you see that already those populations, those communities that have not been served by the state and by law, right? For instance, impoverished Black communities, immigrants, undocumented people that have not been able to rely on the law and on the state and on say, the police, etc., have already started developing alternative ways of dealing with their issues. And you see this kind of thing being picked up, not picked up, but like being developed and gaining massive traction. For instance, looking at Mariam Kaba and so on, people have been practicing this for decades, and we're now getting a lot more airtime and a lot more initiatives around the world picking up that project. And that excites me, and that's where I think we ought to spend that time, rather than spending that time drafting our applications to the ICC and so on.
Lawyers. Thank you, Grisha. I want to give anybody a chance to ask each other questions. I have one, so I'll say it, and then maybe you want to skip over it and ask each other questions instead, which is, one of the sort of unsurprisingly very important points that comes out in, I think, all of your work in different modes is histories of colonialism, and the kind of ways in which I think both very much doctrinally, so Aldo, Barry, and Kamari, I think you all in different ways in the pieces that I was reading were, you do a really in-depth set of work on the ways in which the doctrinal selectivity, the prosecutorial action, right, the ways in which kind of, and Kamari, I think your earlier article, which then plays into the book, and one that I really loved when I read it, this sort of, these modes of short, urgent temporality that are built into both doctrinally and then kind of in practice formulaically, right, in which these ideas are approached in the courtroom, have a quite almost inevitable, if I might be so bold, leaving out of, right, these really important, very particular histories about colonial action. So maybe it's less a question. I want to invite you all to give a little bit of your insights about that, because I see it coming through so much in your work. And then I think, in fact, you have different attitudes toward it. So Aldo, in your work, one of the questions I had as I was looking at your book was that you're quite deliberate, I think, and in a really interesting way in each section at demonstrating what is very much left out. But then I think your points about responsible history in part are modest in the sense that, as you said in your remarks here too, right, you're not asking for that radical expansion, right? The answer is not more. I think Kamari and Barry, in different ways, you also are demonstrating, I mean, I think, right, in Kamari, in your work, it's very much about both what happens doctrinally in the courtroom, but also then the invocation of colonial experience and history in terms of the reception of these actions, right? Both the judgments themselves, but also in, every kind of mode of interaction with international criminal justice in the cases that you're looking at, that, it's invoked in these very emotive ways. It's also received in very specific ways because of the associations that are made with, particular colonial experiences of violence and subjugation. And Barry, also in your work, you really, carefully, I think, and beautifully show doctrinally how both doctrinally and also in these modes of selectivity, that these are histories that don't make their way in. So, I invite you all to speak a little bit more about that, or about how you see each other's work about this, perhaps, because I think you have really different approaches to what that means for history and international criminal justice.
Maybe just to say a few things, just generally, just thoughts, really. So I think the way I see it is that in the book, what I'm trying to show, I guess, or what my research reveals is that the overarching limits of these narratives are really like well defined by the balance of power between and within states. Because criminal law is, in the domestic sphere is linked to the state, and so in the international sphere it becomes linked to, I guess, the interstate a lot of the time, and what's possible within that relationship. I think it's Sarah Kendall's work's quite interesting here, where she refers to states as the shareholders of international criminal courts that limits their material conditions of possibility. I find that kind of perspective very persuasive. That's the outer limits. And then within those outer limits, there's a lot of agency going on with all the other actors, right? So you have a lot of judicial creativity to kind of develop the meaning of crimes. You have prosecutors making all kinds of sort of decisions about which crimes to prosecute, but it's always within this overarching limitation. And that limitation, therefore, I guess, leaves no surprise that themes of coloniality are basically, I guess to use Gritsch's phrase, spirited away. I really like that phrase, by the way. That's a really great phrase. They're kind of spirited away. And so the question is, at least they're spirited away in the sense of the judgment, right? At least in that far. But there are, and I think this was mentioned already, there are nonetheless spaces within these processes, to some extent, if the kind of participants in these processes so wish, to actually put forward some arguments, materials and documents, etc., which push in these directions. So you have, for example, defense lawyers can do sort of defenses of rupture. You have judges can give, very radical dissenting opinions. And then that pushes out into so-called real world, where, all kinds of social movements, etc., can rely on documents that have come to light. And Richard just mentioned this, the information side of these processes, and repurpose them in different spaces, whether it be art, literature, film, whether it be people's tribunals, there are lots of other spaces where these narratives can then come out, and that's why I sort of maybe more positively to some extent say that if we're going to look at these narratives that come out of these courts, they should be seen at best as kind of discursive opportunities, launch pads for further contestation. And I'll just promote someone else's work, which I read just a couple of days ago, because I thought it was a really nice short piece which illustrates this. Alice Panepinto wrote a really nice reflection in Twale Review, examining how the performance and report containing the decision of the ICC prosecutor, Fatou Bensouda, to conclude the preliminary examination into the situation in Iraq and the UK without opening an investigation offers a wealth of information for actors outside that process to repurpose in other media to represent the story of British war crimes in Iraq more faithfully for other audiences. And I think that's a really useful reflection and an example of the possibilities that arise potentially from these spaces. But there's always a but. These are, I think this should, the ultimate conclusion is that if you're aiming for some kind of, emancipatory breakthrough, international criminal courts, international criminal law is probably not not the way to go, frankly. And so on that regard, I guess I find Gritsch's work quite persuasive. So yeah, just some thoughts.
Thanks, Barry. Yeah, and I think that notion of sort of contestation and the notion of closure being resisted, actually, because it's not as much closure as it might be imagined to be, I think is incredibly important, actually, in thinking through a lot of the work that I find it incredibly useful. I'm sure others do too. Aldo, did you want to get in here?
Thank you. I'm collecting some thoughts as I was listening to Barry. I mean, I agree with all that you said, and I'll just expand on some of those points, I think. So yes, so first and foremost, it's clear international criminal law adjudication is still very much a, subject to realpolitik and to the powers. and that explains a lot of the selectivity we have in cases. It also explains, perhaps to some extent, a reluctance to engage more fully with, colonial explanations, because of course they point back to these great powers. So yes, there are. That is sort of the meta framework in which international criminal adjudication operates. Having said that and acknowledged that, international criminal justice is very much a chorus. It is not just judges that make international criminal justice. It is not just prosecutors. You have the defense lawyers, you have the expert witnesses, or indeed the fact witnesses. And those narratives do emerge in the process. So as we know, colonial explanations, for instance, have emerged quite significantly from expert witnesses, the Fords and others, explaining how we have reached this situation in Rwanda or the Congo. And I think those narratives are important, even if perhaps they do not make the final cut in the judgment. I think they still add to the richness of the histories that ICJ, that courts and tribunals write. I also think that, yes, my book, for instance, focuses on the role of international criminal courts and tribunals, but of course, these are not the only mechanisms that produce histories, and perhaps other mechanisms, truth and reconciliation or other mechanisms, are perhaps better placed to write the colonial explanations and structural explanations. And this is why I take the view that I'm not advocating for courts to begin providing those kind of explanations. I don't think they are well placed to do so, but we must just fully acknowledge that we are not going to get a comprehensive structural or colonial explanation of history from an international criminal court or tribunal. We just have to accept that, accept the limitation, and move on. And I say move on because I think there still is good to be had from the explanations that we receive from courts, even though these important explanations will not be found there. So I think that's all my thoughts.
Thank you, Aldo. I want to give Kamari and maybe Gricha able to come in now. I also want to just mark that if people are formulating questions in their mind, you can start to put those out there. If you want to, get your hands raised, and after Kamari and Gricha speak, I'm happy to open it up. So this just gives you a chance to start, prepping your questions for this amazing group of folks. Kamari, go right ahead.
Yes, okay, thank you. And I have to leave in about 15 minutes to moderate another panel. I guess I disagree with Aldo's premise, and I think that there are interesting interconnections and interesting commonalities here on this panel. But I think the point that Aldo ended with is instructive, and it's a wonderful tension for us to think through. So Aldo says that there are limitations that of course the court, international criminal courts, etc., cannot narrativize a particular colonial history, that there are limitations. And what he said is that, but we have to move on, that we have to accept it and move on. And it's a pragmatic conceptualization. It's a way to think about, okay, we have this tool, how are we going to use the tool? How do we apply it to address violence in this world, big violence, like mass atrocity violence, hundreds of people dying, displaced, that lead to thousands, that lead to millions, right? When we think about the nature of violence in this world at this moment, this is significant, and I don't think it's adequate to stop with, these are the limitations of international criminal law, and we have to move on. And Aldo can come in and defend himself in a moment, but I read that as pragmatic, and I think that that's appropriately pragmatic, and it would be a fine resting place if there wasn't an incommensurability with the relationship between what the court, the amount of money spent in international criminal justice, what the court professes to do, and how the court these various courts say that they are there for victims. And if they're there for victims, then we cannot move on and say this is a limitation and we have to move on. That in fact, if we're there for victims, then it also means that the court and the mechanisms that emerge out of activist work, NGO work, other work that is part of the assemblage of international justice needs to address impunity on all levels, not just individuals, and that we need to think about the nature of structural inequality, the nature of land dispossession that actually will continue to produce the violence that we're seeing that is being adjudicated by these courts, but we're not addressing land dispossession and ongoing forms of colonial violence. It's not a thing of the past. It continues to be a thing of the present, especially for those of us who are in North America and Australia and elsewhere, where the most egregious forms of land extraction continue to exist. And so I think that that kind of more moderate intervention is pragmatic, and there's a time and place for it. Like there's a symbolic role that courts can play. They can shape norms and say it is not okay to kill. It is not okay to enlist child soldiers, etc. It is not okay to do that. And there's an important and profoundly symbolic role that these courts can play in that regard. But there is an incommensurability between the kind of the tools that ICL brings to the table and the ability to actually address the kind of ongoing violence that continues, and to address those people who have been victimized by that violence. So I think it's worth continuing to tease out that productive tension and to come to a place where, you know, that we think about what those relationships are, and is it okay to say this is a limitation, but you know we need to move on. What does that really mean, and what kind of status quo are we willing to accept? And by willing to accept, you know, what is the nature of violence that we turn our blind eye to?
Thanks, Kamari. Gricha, I don't know if you want to jump in here. I know this notion of, I was thinking about your point about planned impunity, I think is your phrase, which I thought was really interesting. And then I have a question here from Antun Debets, whose name I'm probably butchering. I'm so sorry, but let's, I want to get Gricha and then turn to you and you can tell me how to properly pronounce your name.
But Aldo might want to also defend.
Oh yes, and Aldo, yes, respond. Sorry, good point.
Yeah, thanks, absolutely. I agree with you, Kamari, that obviously, perhaps the international criminal courts or tribunals will not give us a history of colonialism or a proper account of what's happened, but they and everyone else should try, right? Like it's on everybody. Historians, legal scholars, people with access to the resources or the sources to the archives, to understand, articulate, and hold themselves accountable for, and to be available to be accountable for everything that happened in colonialism, in the trade of enslaved people, and in the continuation of all of these things today. So there, I wanted to ask, it connects with my question on sources, or what I had written. I had written a point down, or a thing down that I thought before we started today about something that I wanted to think about with you all, which is about history, using history as method, right? So I do historical materialism as a Marxist, it's what we do, but we all of us go into the archives. What is our archive? I really love the way that Kamari expands our archive some might say, okay, here's our judgment. That's the judgment of the ICC or whatever, and that's what we read. And then, of course, Barry already told us nobody really reads those things, and it's the media snippets that are read. But beyond those, we see what the judges and what the lawyers involved, what the perpetrators, the victims, the thoughts, the broader societal context in which these cases arose, the history, the colonial history that, for instance, when you look at the Rwanda tribunal, the colonial history that the Rwanda tribunal really does not deal with, in fact, erases, right? So, but I really love the way that also emotion and affect and so on, and way beyond, we can go way beyond. Our archive is the world and our archive is global history right now. Of course, what we are able to reach today, if we are looking at, I love, for instance, Saidiya Hartman's critical fabulation, right? Because the idea there being, she goes into the archives to find stories that, about people that are no longer with us, who didn't write a memoir that we can read today, but through various documents, she will put together a story of what might have happened, what they might have been doing or thinking or experiencing or feeling, right? So the archives that we most would want to access are not available to us. Like we need to understand what it felt like even to be taken from the Senegambia to the Caribbean, etc. We need these. We must develop ways, and Saidiya Hartman gives us a way there to understand, and as a consequence, to hold ourselves accountable for these feelings and the continuations in the present. The purpose of understanding history and knowing history, and it's an ongoing process that will never end. We will never fully understand. We must continue always to understand that we cannot create a true factual narrative of history that is definitive and that is it, and we move on, right? Like in those words. It is going to be a process that will forever continue. Now, in Holland, for example, in the Netherlands, I understand that recent months, in recent weeks, the announcement was made that the Dutch National Archive has digitized and made available online 2 to 3 million, I think, documents relating to the trade in enslaved people that Dutch companies and individuals were involved in, right? So it's great that this is happening. It's great that this is now, these are now stories that we can start to bring out into the open and start to process, as it were. And of course, these stories that, when I say that a lot of some of these stories don't exist anymore, of course they do exist in the way that they've been handed down from generation to generation, from parents to children, and in song and dance and art and literature, in which they do still exist. So in that sense, we can access them to an extent. But I guess my point was history and accountability are never finished, and we can never move on. You know, that's yeah.
That actually, there's an audience question that's going to go precisely to that. But although I want to give you a chance to engage with Kamari, because I know she's going to have to go soon, so I want to make sure you get a chance to engage with that as well.
Thank you, and I'll be brief, but thank you, Kamari, for the challenge first and foremost. And the way I understand this, whereas I say we know the limitations of the histories that courts and tribunals produce, we accept them and move on. Kamari, you are saying, well, we know the limitations. They are not good enough. They are not good enough because of the number of exclusions and injustices. they're not good enough because of the explanations that they produce. That's the way I understand it. And I agree to some extent. So for instance, we often speak about the phrase impunity gaps, whereas actually in reality, there are many more gaps than there are actually accountability and cases where justice has been delivered in the context of atrocities. But the way I look at it, and this is my thought process, is that we have come from an age of impunity during the Cold War, and etc., to an age today where there's a growing expectations of accountability for gross human rights violations, and I think this has, this is epitomized by the ICC and other ICL institutions, and I think they are worthwhile for what they symbolize. They symbolize the expectation of accountability. Now, I agree that we need to continue working to ensure more situations are brought within that regime. I accept that it will remain impossible to bring a number because of the structure of international law today. So, for example, I'm currently doing works on Uyghurs, and we know that they will never see their day in court because of the structure of international law and the United Nations system. So therefore, my position is that, we have the system we have today. Of course, we have to try to continue improving it. But if we were to radically revise it, I have difficulty, first of all, envisaging support for it, for a new system, in the same way as the protocol did not, was all well and good, but then it was not ratified. And I have difficulty envisaging what this new system of law would look like, or justice would look like. So very briefly, that would be my position. I don't know if I answered your question, Kumar.
Kumar, do you want to, I know you have to go in literally, I think, about 1 minute. So I just wanted to give you a chance if you wanted to respond either to, there's a question in the chat about, alternatives for third world countries. There's another question that came in about kind of colonial reckonings and historical injustice that I'll give more voice to in a moment. But also just if you wanted to say anything before you went in our odd configuration where your screen will suddenly flash off.
Yes. Why don't we go ahead? I mean, we only have 15 minutes for audience questions. I think Aldo's point, I think that there are different levels of engagement that we have to work on. We all, wear different hats and take on different missions in this world. And for some, it's black letter law. For others, it's reconceptualizing the tools. For others, it might be different kinds of application and comparative work. And I think it's a matter of us figuring out where we are and what, and I think that that there are times that people who work in the realm of black letter law, who are interested in applying and engaging with the tools of international law, also need to hold in tension that very pragmatic practice with the possibility that we can envision different tools in a different world, that without the possibility of something else, then the kind of violence that is being adjudicated by these courts will just continue. We will not see the end of violence. And so if that's okay, then I think there's a fiction to the tools and the project of justice that's being propelled through international criminal justice, because it's not going to, that these are, as Mahmoud Mamdani has often said, these are political problems that involve political solutions, that law might have a role and it might have a symbolic and a norm framing, one of many mechanisms that can establish and frame what's acceptable in our world, but it has to work alongside other solutions to the nature of violence that continues to this day. And I think that there are different roles that we play. Sometimes we collaborate together, sometimes we teach our students and they become the future for re-envisioning a world where violence isn't the mainstay and adjudication isn't the basis for liberatory action. Right now, for ICL, for many lawyers, after the fact. So after violence has happened, the lawyers go in and do their work. Well, you know, that doesn't produce justice. People have been harmed, and we need to address some of those structural problems. And I think and it's not always on the mission and the plate of everyone at the same time, but it has to be part of the way that we envision a different world, whether it's us or our students. So I'll stop there. I think that there's no one right, but I think we play important roles, and that we need to call on more lawyers and professors of law who are teaching our students. We need to call on them to also incorporate in that work the re-envisioning work that has to happen as we try to together figure out and arrest these forms of structural violence that continue to persist.
Thank you so much. Okay, I want to turn to, I'm sorry, Antoine de Betz. Is that right, Antoine?
Yeah, good afternoon. My name is Antoine de Betz. That's okay. The correct pronunciation, but I do not blame you because 99% of people mispronounce my name. I'm an historian based in the Netherlands, and I have a big interest in law, international law. I agree with the thesis that it is very difficult for international courts to deal with issues of colonialism. And this is so because of one fundamental reason. They are governed by a time regime of immediacy. Why? Because they have to obey the ratio temporis rule, which is an application of the more general rule of non-retroactivity. That is the basic reason why they are not dealing with the remote parts of history. Nevertheless, there are several time expanding devices which may be used by international courts to bring colonialism in the middle, right in the middle of the courtroom. And I made a quick list while hearing the discussions of 6 such devices by which courts, international courts, can bring colonial issues inside the courtroom. And the first, of course, the most obvious one is inviting experts, such as Alison Desforges, who was an historian and who can tell about the past about Rwanda's past. That is the first and most obvious device. The second is that the courts can be creative with the definition of victim, and especially with the definition of indirect victims, children and relatives of the direct victims. They can also be creative with the definition of families and include extended families. That's the second device. The third device is they could use more often the concepts of continuous crime and continuing crime. Continuous crime, which emphasizes duration, and continuing crime, which emphasizes repetition. That's the third device. The fourth device is they could use more often the concept of intertemporal law, and by asking which law system is applicable. The law system which was in vigor at the time of colonialism, or the present one, and what is the difference? They could use the concept of intertemporal law more creatively. The fifth device is the imprescriptibility principle, the principle of lifting time bars for certain atrocity crimes. And the last principle is the principle of state succession, and what it means if states are presented in an international courtroom, and who are they succeeding, and what are the duties of successor states. These are 6 devices, I think, by which courts can expand their time regime. That's what I wanted to say. Thank you.
Thank you so much. That's, I think, really fascinating. And I think I want to just ask the couple of questions that I have in the chat and give everyone a chance, because I think you can probably weave in some of these points about, the possibilities for kind of creative expansion doctrinally and in the work along with these questions. So one from Tanya Attilano is, due to the limitations of international criminal law, what are the alternatives for third world countries combating impunity or the violence derived from colonial history? And I have another question here from someone who doesn't want to disclose their name, but has two really interesting questions. How do you assess Germany's recent acknowledgement of characterizing the atrocities committed against the Herero and Nama in Namibia in the early 20th century as what they are from today's perspective, a genocide? And is there an emerging trend in ICL critically engaging with the past and addressing historical injustices? And if so, what are the potentials and limitations? What could bring this forward? So I think all of those really together are these kinds of, normative points in some ways about what is or what could be happening. So I will be really interested to hear what you all kind of have to say to that. Yeah, and then we only have 8 minutes left. So, solve colonialism, go. Just kidding. Anybody want to tackle those? Or any of them?
Okay, I'll bite. Sorry. I also saw in the news today that Belgium is giving back the Congolese artworks that they're holding. They're giving them back to the Congo, which is quite, I don't know, I'm like obviously going to be cynical and say, oh, it's like corporate social responsibility, it's like good PR and so on. I mean, I think these things, of course, are a start, and they need to be they need to be a part of a much larger program. For instance, we impoverish the third world through global debt, right? More money flows from third world countries to the metropole than the other way around because of the way that, lending from World Bank and IMF. So if we really want to make reparations, that's a place where we could start. And then using the word genocide is good, it can be meaningful. Giving back the artworks, etc., is also great, but there is so much more that needs to be done. And I'll leave it there. And I see there's some more questions in the chat.
Yes, there's some really interesting points in the chat that were just made. So I don't know if I should read them out, but also Barry and Aldo, I don't know if you want to get in on this coloniality question, since I know you've both addressed them, or if you feel like you've said your piece on that point, that's fine too. We have a question also in the chat that I think goes to some of both of your work about the work of historical experts. So what if actually we ask the people who know a lot about history to contribute to the work that is going on, rather than kind of over promising and under delivering. And this is an eloquently written contribution. So that's why I'm encouraging everyone to actually look into the chat and read it for themselves. But this question about sort of, can you do better fact finding if you actually have professional historians involved, which I think, in transitional justice, we've long had this question about sort of the ways in which historians were not involved for a very long time in the production of the field, and what that meant for, not just legalism, but history, right? This sort of notion that the notion of lawyers and judges as producing history, which I think Barry and Aldo really comes up in both of your books. So I don't know if you've thoughts on that, sort of that professional point as well, or expert point as well. So, yeah, Aldo.
If I could briefly, and then I'll hand over to Barry. The answer is yes, absolutely. So clearly, the ultimate goal of a criminal trial is to decide the guilt or innocence of the accused. But to understand what has happened, all of this has to be placed in a explanatory framework, a historical, social explanatory framework, and that can be enhanced by the involvement of professional historians, sociologists, and the like. And my point in the book is precisely this. It's international criminal courts and tribunals cannot afford to focus, on the narrowly defined guilt or innocence question. They perform a far larger function of uncovering the truth, and therefore they have to give the opportunities of contested interpretations of history to be aired and examined and cross-examined in the courtroom. And that in itself performs, I think, a very important function of uncovering truth in addition to assigning guilt or innocence. So the answer is yes, and equally with colonial explanations, as I mentioned earlier, so all opportunities should be given to experts to bring these explanations out, as Antun has mentioned, through experts and through other means in the courtroom. I think, yeah, that would be my reflection.
Yeah, so a lot of good questions, which is why I was hesitating to answer, because they're just very difficult questions, to be honest with you. I think in relation to what avenues are there outside of international criminal law, I mean, obviously, in immediate sense, as a lawyer, one automatically thinks of the kind of traditional transitional justice toolkits that kind of get banded around, truth commissions and the like. But I think ultimately, what's really needed is, political movements, essentially, advocating for political change to the structures that enabled colonialism in the first place, but continue to enable the structures of domination in the present. And I think that, look, I'm a huge fan of Gritch's book, so I keep referring to it because I am a massive fan. But I think that Gritch's book really brings that out in the conclusion that, we need to be bold and look for human emancipation. Now, I don't know, I think if I had the answer to that, that would be great, but I don't have the answer to that, and it's not my project. But I do think that that is where, I think that is, that's where the investment of our thinking should be directed. I do feel like I felt this odd sense when I finished my PhD in the book, of, have I, really directed my attention at the right object of inquiry? And I wonder whether other panelists felt the same, in the sense of, you write this kind of detailed analysis to reveal that actually, the object that you had held out hope for in the beginning actually is very limited, constrained, and as Kamari was saying, problematic in so many ways. And then, so where to next? And I think that the project, that the most important projects now are, leaving even academia aside, are those political projects, those political movements that are trying to figure out avenues to change these structures. And we as academics can do our best to kind of reveal and help understand, avenues that maybe aren't as emancipatory as they could be. But I'm not sure how good we are necessarily at coming up with, creative strategy solutions or novel ways of actually finding paths forward. Okay, so that's a rambling answer to that question, wholly inadequate, I understand. And in relation to acknowledgements and apologies, etc., for colonialism, I need to look at the specifics of actually what was said. I must confess, I know about it, but I would like to see the wording in particular. I think what's important with these is that they recognize the ongoing nature of this and don't confine to the past. And I think, Zena, in your work, you might have something to say about this as well, right? I think the temporal element here is interesting. It's sort of apologies for past atrocities. And this is why I say I need to look carefully at the wording, but it's important to not give the impression that this is kind of a thing in the past and that has, holds out no connection to the ongoing realities that are experienced by many in the present. So that's what I would say. So those are just a few thoughts on some of the questions. Thank you so much for those questions.
Thank you, Barry. And yes, I think that it goes back to your closure point, actually, because I think a lot of what we see in these kind of apology acknowledgements, and I talk about this a little in a forthcoming article, is exactly this mode of, the mode of sort of we've done the thing and now it's over, is precisely goes against, I think, the points that were being made about continuous and continuing crimes and violence, right? And sort of how we conceptualize justice that is not closure. So, I think all of those questions and these kind of broader political ones are really big ones. And perhaps the perfect place to leave the conversation, because we are at time. So everyone can, afterwards think very hard about what the answers to these incredibly challenging questions are. If you have not already been persuaded to read all of the books you've heard about today, I hope that you will immediately buy them or have your libraries buy them or read them in any form that you can. Because they're all really brilliant contributions and quite deep and fascinating in different ways. So I really encourage you to engage with them and with all the other scholarship from everyone who's spoken today. And I want to thank you all for being here for a long session on Zoom when we all have been doing this for a very long time now. And to just thank again Barry and ESIL and the interest group for bringing us together and for allowing us to be part of this conversation. So I hope you all have a good day/evening wherever you are. And that is it, unless Barry, you have anything final you wanted to say.
I just wanted to say, first of all, thank you to Zena for the wonderful chairing of today's session. That was expertly done. And I also wanted to extend a thank you to the panelists. I know Tamara's not here, but thank you for giving your time to this event. I hope you enjoyed it. And I also give a personal thanks to everyone who attended. Thank you so much especially for the excellent questions. This was, as I said, an event of the ESIL interest group on international criminal justice. So please feel free to visit our website for more information on what we do and how that works. And I'll leave it there, but just to say thanks everyone, and I wish you a good evening or morning wherever you may be. Thank you.
Thank you very much, everyone.